Abusiamu bi akwaba. No video bi ha me bebo ama obi ahwe. About Ghana former director of Ghana School of Law, Kweku Ansasari. Or the same be to ya say President Mahama any Chief Justice talk when you her hair cause about petition to remove her no or the blame in Nama Akufo-Addo. Now I didn't know the blame in Akufo-Addo. Former director of Ghana School of Law or say blame in every former President Akufo-Addo because before say Akufo-Addo be free power. Before so be free power yet this 7th January 2025 no. Na petition be da who was say petition be by against a Chief Justice here President Mahama person yin free hoy. Na kwan President Akufo-Addo efa so dismiss that petition no wan fa the right way until that President Mahama by those same petitions no asa ba bi when this time around no President Mahama act upon it. Enti or the blame ni Akufo-Addo say Akufo-Addo am for the right channel so and this answer that petition until that those petition na ba say Chief Justice get through tokunu eda mani mu na sa kwa ahead the chire mu say ekwasifo amo de President Mahama court say opeso yi Chief Justice free one na odinsem to just say eno no dead on arrival because President Mahama follow the right procedure and odi yi Chief Justice tokunu everyone mean say obi am enko ensem a former director of Ghana School of Law Kweku Ansasari edituja ewa abra okasaye TV so mumi anko he mean say obi am anko he.
I am not a lawyer. There have been several lawyers. Tadio Sori has also written lengthily on this matter. But let's speak to the former director of the Ghana School of Law, Kweku Ansasari. He's joined us in studio. Good evening to you, sir. Very grateful for your time tonight on 505. So, this whole legal issue. Let's see. Did the president act unconstitutionally by referring to the petitions to the Council of State?
No, not at all. Everything he has done is in accordance with the Constitution. And I don't think that anyone can fault him for forwarding the petition to the Council of State because that's a constitutional requirement that upon receipt of the petition, he shall hold consultations with the Council of State. And you can only do so, when you forward the petition to them.
But they're saying that Article 146 is very clear that the president has to listen or hear from the person who a petition is against.
Where is it in the Constitution?
So,
where is it
the Chief Justice himself
where is it
has written.
It's a convention.
It's a convention,
it's a
but
convention.
Not a demand.
It's a convention. So conventions and the practices together, support the constitutional process. So it is not everything that can be written into a constitution. So the constitution merely captures the key ingredients. So, but it's always a convention that if there's a complaint about somebody, the rules of natural justice require that you show it to the person, against whom the petition or complaint has been lodged, to also look at it and respond. But that doesn't prevent the president from forwarding. So it can be done simultaneously. It can also be done even after. That's why we say that it is not incurable. It is not so fundamental that can result, in throwing away the petition. Not at all. Okay. I disagree with anyone who will say that the president, has subverted or violated a constitutional principle merely because he didn't show, the petition to the Chief Justice.
So the Chief Justice has responded. She says, request to be given copies of petitions submitted against Justice Gertrude Araba Isaba Saki Tokono, Chief Justice, before conclusions of consultations between His Excellency the President and the Council of State under Article 1466.
Yeah, that's
and
in
it's
order.
copied to the President, Honorable Doaja, who Chairman of the Council of State, the Honorable Justice Sophia Kufu, Member of the Council of State, and also the fourth is the Council of State. And 1, 2, 3, paragraph 4 of that letter says, up to date on 27th March, I have not been shown the 3 petitions mentioned in the communication of 25th March 2025 or given an opportunity to respond to them, which material is expected to form the premise for the consultations between the Council of State and His Excellency the President under Article 1466 as to whether there is the need to set up the committee of inquiry described in Article 1466 and 1467 for the trial of any issue raised. As you are aware, when a petition for removal of a Superior Court judge under Article 1461 is forwarded to the Chief Justice, the first requirement of due process is for the Chief Justice to bring the petition to the attention of the accused judge and to obtain their response to the petition. This is the right afforded every citizen in justice delivery and is provided for in the Article 146 procedure. In my time as Chief Justice, she goes on to give some explanations. She says, respectfully, in the case of the Chief Justice, please allow me to submit that it is the combination of the evidence in the petition and the response of the Chief Justice that provides the material for consultation between His Excellency the President and eminent members of the Council of State under Article 1466. These 2 sources serve to guide whether a prima facie case has been established such that a committee of inquiry should be set up under Article 1467 to inquire into whether the Chief Justice may be removed from office. This is the direction of the Supreme Court in the case of Ejechum versus Attorney General and Akwete 2005-2006. So the Chief Justice says, I mean, before you even proceed to consult.
So you see, the Chief Justice is requesting in accordance with a binding decision of the Supreme Court that in the Jechum case, their lordships made it quite clear that you cannot proceed unless you have shown or given a copy, of the petition to the person directly affected by the petition. That's what I meant by the convention. It's a convention. You see it or find it, boldly written in Article 146. But if you look at Article 146.1, Article 146.1, in the case of a justice of the Supreme Court, and Article 146.4, again, in the case of a justice of the Supreme Court, the requirement is that there must be a prima facie case, but you cannot find the same element in Article 146. But because the Chief Justice is first and foremost a justice of the Supreme Court, whatever affects a justice of the Supreme Court equally affects the Chief Justice as a justice of the Supreme Court and also the Chief Justice of the judiciary.
Okay, so she says, I am by this letter humbly and respectfully asking His Excellency the President and eminent members of the Council of State to forward the petitions against me to me and allow me at least 7 days after receipt of same to provide my response to you, which response can then form part of the material that you conduct the consultations anticipated under 1466 before the possible setting up of a committee of inquiry, Article 146.
But if I were the Chief Justice, I won't even go this far. Allow them to do it, and then when they finished, a fundamental requirement has been breached. She was not shown, she was not heard. So upon what basis
did you form the committee?
Was it forwarded, to the Council of State? Because you've heard, one side only. But the rules of natural justice require that hear the other side. That's why we have the alteram partem rule. So you cannot condemn a person unheard. So whatever the Council of State, whatever consultation the council may have with the will come to naught because of that breach of the rule of natural justice.
Can the council within that consultation say, okay, let's forward same to the Chief Justice for her to respond?
So it means that the president forwarding it was premature. The president jumped, the gun, jumped the hell there. You need hop, step, and jump. You need to go step by step.
So if the president decides not to do this, will he have breached any constitution?
Sure.
Not to give the Chief
the rules
Justice
of natural justice is fundamental. Fundamental. And if you look at Article 19 of the Constitution, all that is going on now will end up in a requirement of fair trial. So where is the observance of the requirement of fair trial? And therefore, what the Chief Justice is saying is that, fair enough, you have not observed the rules, but I am the Chief Justice. I am demanding. I mean, she was very charitable in saying that she was requesting. It's a demand.
Okay.
Yes, she shouldn't be pliable. This is what the law says. And the law is embedded in the bosom of the Chief Justice.
Okay.
And she's, telling them this is the law. It is the law that is speaking. So whatever pronouncement the Chief Justice is making now is as if the Constitution is speaking. So we are all trying to develop a jurisprudence, around the removal of the Chief Justice. And maybe by the end of 2029 would have developed and established jurisprudence. If you want to remove the Chief Justice, these are the things like she's
so this
referring
should
to a
be
J-chum.
This should be considered by the Constitutional Review Committee or that is
I'm
going
sure
round
they will, because this thing started from
the
Akwa's
Shraj time. Yes.
Kingsley Akwa, when the J-chum, yes, and the Supreme Court said no. You cannot just, assemble, facts, however frivolous or vexatious, and try to use those facts to impeach the Chief Justice of the Republic. The Chief Justice is the head of an independent branch of government. That arm of government is the judiciary. And under the Article 125 of the Constitution, the Chief Justice is the head. The Chief Justice shall be the head. So the Chief Justice's position is, like the president's position. Each of them, each of them is a head. And, by parity of reasoning, the equation will be the same. The head of the judiciary is the Chief Justice. The head of the legislature is the speaker. And the head of the executive is the president. The president, cannot just enter the pinnacle of the judiciary and claim to have received a petition. Therefore, it is only the Constitution that has allowed the executive to be having some sway over the judiciary. And I think that, like you rightly pointed out, the Constitutional Review Commission should look at this, the circumstances, the processes involved in the removal or seeking the removal of a Chief Justice. It shouldn't be different from how we how we impeach the president.
Can that also be extended to independent state institutions like Shraj, Electoral Commission,
Governor of the Bank of Ghana,
and all that?
Yes.
Can we also look at that process as well?
Yes, we can, but they are not on the same pedestal. When you take the branches of government, so far there are only 3. If we add the fourth estate, we may have 4. But the fourth estate hasn't, the root is not as deep as the first 3. Yes. So if you take the judicial, the executive, and it is not for nothing that, when you take the Constitution, it's been arranged in such a way that you need to find the Constitution, go to Article 57. The executive, Article 57 deals with the executive and all that. Because the legislature is separate and distinct, you have to go to another article, which is Article 93. Then you find it there. When you exhaust that and you want anything about the judiciary, you go to Article 125. Now, each of the 3 branches has its own scope. But there's an exceptional scope in respect of the judiciary, Article 127 guarantees the independence of the judiciary so that it can be insulated from political interference and control. So in whatever we do, we should be very careful the way we handle matters pertaining, to the removal of the Chief Justice, because the Chief Justice is head of another independent and separate, distinct branch or arm of government. That is why we have separation of powers. But then, in order for injection of efficiency and for government and governance to be effective, they cooperate. So that they are not, in watertight compartments. It is all, to ensure that we don't create tyrannical institutions and tyrants, all in the name of governance.
Okay. So in this, can the Supreme Court have jurisdiction over these two suits that have been filed? One by Ebenezer, an individual, and then the Member of Parliament for Otafo. They are all seeking to invoke the powers of the Supreme Court to declare that the President's action, without having heard first from the Chief Justice or even forwarding the petitions to her to respond, has erred. It's unjustified, as he calls it, unjustified interference in the independence of the judiciary, or is a breach of the rules.
No,
of
I don't think that we can say that merely forwarding a petition in accordance with constitutional requirements amounts to or constitutes a breach, or a violation of the Constitution. No. Rather, it is in clear observance of constitutional requirements. The President cannot stop any Ghanaian from implementing Article 2, Clause 1 of the 1992 Constitution. So, Article 2, Clause 1, if you have the Constitution, you look at it, you say, a person who alleges.
That's true.
A person who alleges. So any person who alleges, that the Constitution maybe is being, a provision is being violated, or they can go to, and the Constitution empowers such a person to go to the Supreme Court to test the legality of what has been done. So if the person exercises the constitutional right, how do you blame?
But would the Supreme Court have jurisdiction?
That's why they are invoking the original jurisdiction of the Supreme Court. And when you are invoking, you see
it's the Chief Justice who empanel the judges, and she's the one who is quote unquote under contention, whose authority.
But that shouldn't trigger any fear. Any such apprehension will be illegitimate because the Chief Justice is the head. That is why the Constitution says in Article 146(4), in respect of a sitting justice of the Supreme Court, that a prima facie case, so that frivolous petitions can be thrown out. Okay. Whatever it will be the case, it is the Chief Justice who is the head. If a pupil or a student makes an allegation against a headmaster or a head teacher, until the head teacher or headmaster is removed, it is the same head teacher or headmaster
who preside on that same matter.
So I don't see anything wrong with it. And we must have confidence in our institutions. If we have confidence in our institutions, we will know that whether the Chief Justice is empaneling or not, we have judges, isn't it? So how many? Say 5. If I were the Chief Justice, I won't sit. All I'll do is to refer the matter to the first 5. So the first 6, if I eliminate myself, it means that you have 5. The 1, number 2, 3, 4, 5, and 6. They will sit. That's all. You have empaneled. What is wrong, with that? So if I were the Chief Justice, that's what I'll do. And I wouldn't, be apprehensive at all. When I was asked to step aside as director of the law school, I continued until 31st August. I carried out my functions. I did everything. I appeared before the General Legal Council. They wanted this thing. I interviewed. I recruited staff and this thing. I had no apprehension whatsoever. I knew I would do the right thing, and I did. So let us, have confidence and say and hope that the Chief Justice will do the right thing. After all, it is a petition only. It is a petition only. We are now trying to inquire. This is the inquiry stage. And the Council of State has two very eminent former justices of the Supreme Court. Her lady Justice Vida Kutubanfo, then a former Chief Justice Sophia Kufu. You know, and then you have a former Speaker, the Right Honorable Do Ajaho. I don't think that these are people who are going to tiptoe around the issue and play around it. This is a very serious constitutional matter, and everybody is watching. The whole world is watching. The whole world is watching. And we are also watching. We also make our contributions. I may condemn the processes leading to the appointment of a person, but once the person has been appointed, I have to respect authority. That's the fun of the practice of law. Tokonu was, mentioned. I was interviewed by several media houses, and I said it was a mistake because she was far too junior. However, Parliament vetted her and approved, and she became the Chief Justice. So I went on air to eat my humble pie, and I said, as far as I'm concerned, she has been appointed. She's my Chief Justice. She's Chief Justice of the Republic. She has been appointed under the Constitution. The moment she was vetted, approved, and sworn into office, she ceased to be the appointee of the president. She became the appointee under and of the Constitution. That's the distinction we need to draw at all times. Once the person is appointed, the person ceases to be an appointee of the president. Now here, at this point, what I want to say to her leadership, Chief Justice Tokonu, and future Chief Justices is to be careful about how they comport themselves when they come into office. I was here. You entered that day, you sat there.
Yes.
And I said I didn't like the body language of Justice Tokonu in the 4 seats, vacant seats saga.
Yes.
Here, you interviewed me, and I said I didn't like.
When Appenyo went to court.
Exactly. And I said she should be careful because people will use it against her. And this is what, but it doesn't mean that she's incompetent. That is not proof of stated misbehavior. We all have our faults. That's a style. And if she chooses to manifest certain traits which are roundly condemned, they should not be used as they, because when the Constitution says stated misbehavior, it is not your body language. Each of us has his. Some
people are stating procurement issues as well.
I'm not aware of procurement. If there's procurement, let them. How did the people come by, the information? So I'm not aware of any procurement. That if there's a procurement, this thing, it is not for me to go into. But they're looking at the information put out. And I've just been given a copy of a letter. If I were Chief Justice Tokonu, I won't write this letter in the first place. You go ahead and do all that you can. When you finish, then I say, but I also, where is my input? And that would be a clear violation of exactly. So this has come. She has just rather given them,
the opportunity to right their wrongs even from beginning.
If I were, to advise her, I won't commit this blunder again next time.
Somebody is asking a question, and I want to ask you that question. He says that he's confused, but he says, can someone go to the Supreme Court to stop a president from executing his constitutional mandate?
No. The Constitution says do this. If you don't, you are subverting the Constitution. Then you can go to court to impeach the president for for subverting the constitution. But if the constitution casts a duty on the president is legally and constitutionally enjoined to perform that duty. Yes.
Wow. So in the coming days, we are likely to see a lot of legal things that are going to happen.
And we'll be here to explain.